Good morning from London. Thank you very much for joining us in our webinar today, which we will be looking at investigations, enforcement, and compliance issues. My name is Bei Zhao. I'm the Asia Pacific editor at the Legal 500. Investigation work is filled with legal and practical issues for which there is not always one appropriate resolution. In recent years, organizations of all sizes, sectors, and markets have been faced with managing internal investigations in response to an increase in white-collar crime and misconduct risks. This webinar, brought to you by the Legal 500 and Fanda Partners, is designed to provide general counsels and risk and compliance officers with guidance on the practical steps that can be taken to mitigate, manage, and overcome the different stages of an investigation in China, from the initial complaint to the outcome. I'd like to thank our partner firm for today's session, Fanda Partners, and our distinguished speaker, Kate In, for joining us today. I'll be introducing Kate shortly. Before that, I'd like to outline what will be covered in today's webinar. The webinar will last about 60 minutes, which will be looking at internal and external investigations triggers and why companies are investigating misconduct, how investigations are conducted in China, practical tips for handling personal information and data transfer during investigations, disciplinary actions and impact on corporate liability, as well as increased concerns in relation to supply chain compliance and human rights, and potential compliance conflicts between the US law and the PRC law. We would like these sessions to be as interactive as possible, so please do send us questions through the Q&A tab, and we will address your questions towards the end of the webinar. Now with me today is Kate In from Fanda Partners. Kate splits her time between the firm's Beijing, Hong Kong, and Guangzhou offices. And Fanda's regulatory and compliance team has an outstanding track record of serving as lead counsel to large multinationals and Chinese companies, most recently in relation to internal investigations into allegations of fraud, among other matters. Kate has represented clients in a range of areas such as anti-bribery, anti-unfair competition, data protection, accounting fraud, securities law, anti-money laundering, conflicts of interest, trade secret and sanctions and export control. With deep insights into government enforcement and market practices, Kate is highly sought after in most challenging government enforcement and corporate investigations, particularly those involving multi-jurisdictions. She has successfully defended clients in government enforcement and helped clients avoid hefty penalties and headline stories. Kate participated in various high-profile cases such as GSK Chinese commercial bribery prosecution and Siemens FCPA monitorships. Kate will share her insight into the above-mentioned areas in detail in today's webinar. I'll now be passing over to our speaker, Kate. Kate, it's great to have you today.
Thank you. Thank you for your kind introduction, Babe. It's great to meet you all virtually. Today, we're going to share how to manage internal investigations in China, as well as some tricky issues with regard to supply chain compliance. Let me share my screen. Okay. So internal investigations has getting more tricky in China nowadays. Especially with the passage of PIPL, the Personal Information Protection Law, and data security law last year. And in the recent weeks, there has been quite a few implementational measures passed in connection with this two law with regarding to security assessment for transferring information out of China, as well as the transfer mechanism. Like in China, it's important to note that when there is internal investigation, when there are informations to be transferred, it's not only personal information that we need to be concerned. There are other kinds of information the government is concerned, such as important data. And we will discuss that in this seminar as well. And also, when there are external investigation by foreign government, whether it's a criminal investigation or it's administrative regulatory investigation, sharing, providing information, any data, not only personal information or important data, basically any data cross-border would be subject to government review. And that poses challenges when there are external investigations by our government. And oftentimes there are internal investigations conducted afterwards. There may be self-report to a foreign government, and how things may be judged from hindsight is a tricky issue as well. So we'll discuss in more details later in the seminar about how data security law, Article 36, is going to impact internal investigations in China. Yeah. And also supply chain is getting pretty tricky. Well, companies are setting up compliance protocols, systems for ensuring supply chain compliance to avoid forced labor. There are potential violations of Chinese law, and also how to manage PR issues is a tricky issue, and we'll discuss those in more details in this seminar. So there could be different ways where internal investigation is triggered. Again, nowadays, with the COVID-19 and with like economic getting slowed down, and some companies may be terminating, laying off some employees. We are seeing more whistleblowing reports in China than normal. And how to handle those? When do we need to start investigation? And also there could be media crisis. For example, every year, Chinese government, the Chinese CCTV has a gala, the March 15 gala, and there are misconducts of companies being reviewed. And immediately after the gala broadcast such misconduct, there would be investigation by the government, whether it's PSB or other agencies. We have seen companies after the gala is released, there will be immediate enforcement, and oftentimes in those kind of situations, companies will do investigations themselves as well. So when there is an allegation, we would want to assess whether we will reach out to the whistleblower. Whistleblower is always a good source of information. Based on my experience, it's important to respond very quickly, and also to draft it in a tone that's not standard language from the company, but something that's really tailored to the allegation. And in a way that to build a connection with the whistleblower, so the whistleblower is more willing and comfortable to speak on the phone or even in person. So we had success where even an anonymous whistleblower gradually started talking with us on the phone and they eventually meet us in person when they feel like they are connected with the investigator really care about what they are reporting. And it's important to handle communication with the whistleblower in a proper way, because if his whistleblowing report is not addressed properly, then this whistleblower may report to the government and or disclose it on media. We have encountered different situations in the past. When there is government investigation, whether it's appropriate to conduct an internal investigation is a pretty tricky issue. When there is, for example, when there is a criminal investigation in China, we would advise clients to be careful in terms of whether to start an internal investigation, because an internal investigation before the government conduct their own criminal investigation, before they look at the documents, the company look at the documents before they interviewed a witness, the company conduct an internal investigation and interview a witness, may be viewed as obstruction of investigation, and even may be viewed as an intent to distract evidence. And such evidence may also be viewed as contaminated and not fit for criminal investigation in the past and down the road. So when there is a criminal investigation by the PSB in China, we would recommend clients to be really careful to consider whether to start an internal investigation. And if it's necessary to conduct an internal investigation, we would communicate with the PSB so that they know the company is like say a multinational company, and according to its policy, the company needs to do some self-assessment as well, so that it won't be a surprise to the government. And also the evidence need to be preserved in advance so that it's not contaminated. And when there is a foreign government investigation, not Chinese government investigation, then we would need to think about the data security law, which I'm going to talk in a few minutes. And in China, under PRC law, there is no attorney-client privilege concept, no real attorney-client privilege concept. In a criminal defense, there is very limited privilege concept, but it's nothing comparable to that under the, say, US law. But however, under the PRC law, there is the lawyer's law, Article 36, which requires PRC counsel not to disclose confidential client information. And so in reality, the PSB or like other enforcers normally would not come to external counsel, PRC counsel, to ask for documents of a company. However, they can go directly to the company's in-house counsel. And we have seen that the investigators in China are getting more familiar with how multinational companies work. And there are major investigations where we defended our clients. The investigator, the government investigator, would come directly to in-house counsel, to the compliance in-house counsel, to collect their laptop, because they believe they would find information they are concerned on their laptop. So with that in mind, for like pretty sensitive documents, even though there is no attorney-client privilege in China, our clients often would have an external PRC counsel to store those documents for them. In that way, it helps them to preserve these documents from government investigation, and also help to avoid potentially waiving attorney-client privilege for foreign government investigation. When I say foreign, for this presentation, it refers to non-Chinese government. And there are like one difficulties we find companies often face in China is the digital marketing, the fast media spread through like Weibo, WeChat, articles, etc. So adverse negative press report may quickly spread out. And in that circumstance, like it's important to definitely working closely with PDR team. However, oftentimes working with a PR company is not sufficient to control the fast spread out of a negative press report through digital media. But there are tools companies can use. For example, where we see there is like a whistleblower who not only reports to the company but also posts this online, and it's quickly spread out. If we look at how it spread out, we may notice that there is not only media that are spreading it. There are certain, like we call it like a 水军, so like a certain set up accounts that are helping to spread this out, and it's likely to be controlled by a competitor. And this kind of conduct is illegal, and actually is a criminal violation under the PRC criminal law. It can be 非法经营罪, so it's an illegal operation, a crime of illegal operation. So there are legal tools we can leverage to protect a company when a company faces media crisis. As we are going to talk about the supply chain compliance in the later part of the seminar, we're seeing that with the chip companies going on, and there are like negative media coverage of legal conduct of companies, but it may attract lots of people's attention. And to handle those, it's important to ask to align internally so that the PR team is aligned with the legal team in advance. So for example, if we're taking off products from Xinjiang off the shelf, we want to make sure that this is aligned, the business team is aligned with the legal team, and figure out a way to manage it from a PR perspective as well, not only a legal perspective. And we will talk about cross-border elements shortly. So for cross-border elements, it's important to note the Personal Information Protection Law, PIPL, and the Data Security Law passed. And for data protection, it's not only these two laws, there are other laws that are relevant. There are cybersecurity law, which has been in place for a while. And there are criminal law provisions. There are quite a few criminal law provisions. So if certain like collecting personal information is not legally obtained, it may violate criminal law as well. And there is a civil law code as well. And there are various measures passed. And for the criminal law perspective, we have seen is most actively enforced in the past few years. So after the cybersecurity law passed, after the public has been very much aware of their rights to privacy, to personal information rights, and also the government noticed that personal information, important data, etc., may impact national security. The enforcement for data protection has really stepped up in the past few years. And here you see different regulators in China who are active in the data protection space. For the Ministry of Public Security, they are active in both criminal law enforcement as well as regulatory enforcement. As I just mentioned, the data is becoming a topic that really affects national security as well. So the Ministry of National Security is heavily involved in data protection and cybersecurity in China as well. We have encountered national securities bureaus enforcement in a number of cases, including cross-border enforcement cases, as well as cross-border litigations. Where there's a litigation in the US, enforcement by the US DOJ, and there needs to be data provided cross-border. And the data security law, which passed last year, which is address not only personal information. Personal information is covered by PIPL, but all other data are covered by the data security law. And data security law is drafted, is driven by the national security concern. And the MIIT is very active in the regulatory enforcement space. Not too much in terms of internal investigation, but in terms of cross-border data transfer, they're involved as well. And of course, CAC is heavily involved in data protection. You may recall last year, there like Didi and other companies encountered the network security review, and that was driven by CAC. And there are other, I want to note that TC260 is an important organization which which draft national security and draft national standards for data protection. And while there are various laws in China came out in the past few years, generally the laws in China are not as detailed as those drafted in a way that leaves space for administrative interpretations. So national standard play a really important role in interpreting what the law says. Those national standards are mostly drafted by TC260. While those are not mandatory national standards, we have seen that when government make enforcement, they would look at those national standards and check whether those are followed as a way for them to interpret whether the company has been following the law in the correct way. And so, as I mentioned, that when there is foreign government enforcement, Either whether it's enforcement authority or it's a judicial body. There is a prohibition in terms of providing those for under Article 41 of PIPL for personal information and Article 36 of DSL data security law for all data. A company is prohibited to provide those information to foreign foreign authorities, to a US enforcement authority. And in terms of judicial body, how to interpret this is not entirely clear. And a more conservative way is to include all foreign courts. So basically, if there is a discovery order by the foreign court, the Chinese company can rely on data security law to refuse, protect, providing any data. However, we understand that's not really recognized in foreign courts, so companies will be facing a difficulty in terms of whether to violate the DSL or PIPL or providing those information, not providing those information to foreign courts or foreign authority, and then they may face sanction. But now with the security assessment measure becoming effective September 1st, companies may consider going through that security assessment approval by provincial level of CAC to get information outside of China. That's the only public available way to get information approval for getting information cross-border at this moment. And in terms of there is a foreign investigation, government investigation. We would need to consider not only personal information, basically any data that needs to be reviewed by the Chinese government before it's transferred outside of China. If it's not an enforcement situation, if it's an internal investigation situation, well, we want to consider whether we are planning to self-disclose this to a foreign government. And because when we are facing enforcement, it will be judged from hindsight. So before we transfer the information outside of China, we will need to consider down the road how this information is going to play out when the company is conducting a self-report. Of course, I think everyone knows that before we transfer information outside of China, we would need to consider a state secret review. This has been in place as the industry standard for a long time. And as I mentioned that in China, we not only need to think about personal information, but also important data. And so even if we're in a situation where we do not foresee there is government enforcement, we're just doing a purely internal investigation, we would need to consider the information that's shared cross-border would include important data. And the important data refers to non-public data or confidential information that's not state secret, but would impact or endanger national security or public interest of China, or impact or endanger society as a whole in China. If such non-public data or confidential information is leaked, lost, destroyed, or stolen, modified, or otherwise illegally processed. So for this definition, you can see it's not very concrete. So we participate I participated as an expert helping drafted a national standard of important data identification, and for that is provide more details about how to identify what's important data. And the one we're doing internal investigation, it's possible that some of data may be viewed as important data. For example, financial data with regarding to transactions with SOE. Not for every SOE, but certain kinds of SOE may be more sensitive. But when we do, for example, anti-corruption investigation, oftentimes we would need to look at financial data. So we will need to consider whether those are important data. And also, I want to note that for cross-border transfer, it doesn't need to be like I email this to a foreign recipient. It can be someone who is based outside of mainland China. It can be even Hong Kong. Even though Hong Kong is part of China, but as a judicial jurisdiction is cross-border. So like someone doing investigation in Hong Kong, reviewing data in mainland China is viewed as cross-border data transfer. So that can get really tricky in internal investigation space. And for personal, I mentioned like for important data, this one in the cybersecurity law is not clear, like whether important data needs to be stored in China, but with the passage, with the 2 weeks ago when there is cross-border data security assessment measure came out. There is one provision note that for any important data to be transferred outside of China, it needs to be reviewed by the government in advance. So basically, all important data need to go through security assessment before cross-border. Not only for important data of CIO. And based on our experience, many companies would have important data. And for personal information, the one we transferred cross-border, if it's above certain amount, it needs to go through security assessment. And for if a company possesses more than 1 million personal information, even though it's transfer one piece of personal information, theoretically speaking, it needs to go through the security assessment and approval by the government in advance as well. If the company has 10 million, have a sensitive personal information, that's threshold is lower. So with that in mind, for cross-border investigation, it's going to get more tricky. But in the internal investigation, one thing that we want to, of course, we first need to assess whether the information can be transferred out of China. And for that, we need to evaluate whether it's important data, personal information, and for personal information, whether we hit the threshold that we need, so that we will need to go through a security assessment and approval by the government in advance. And even without reaching the threshold for personal information to be sent cross-border, according to PIPL, that the company would need to get a separate consent. So a separate consent is a unique concept under PRC law. So the consent cannot be bundled together. It has to be separately laid out and separately consented by this individual before its information can be sent cross-border. And for an internal investigation, oftentimes we would need to investigate an employee who is engaged in wrongful conduct. And we would need to look at his emails and other information without his knowledge. And the information may be disclosed to a foreign authority or be sent cross-border without this individual's consent. And even if this individual has consented, he can withdraw his consent. And fortunately, in the PIPL, Article 13, there is a provision too, which noted that if the company has employee management policy which has been passed through the domestic approval process. So like in China, for a company policy to become effective, it needs to follow certain process. It has to go through a domestic consultation process before an employment handbook to become effective. If the company has followed this process, and in this policy, there are we lay out how personal information may be collected, processed, and transferred in advance, and it's necessary for companies management of employee data. Then we can rely on this and as an exception. So it's important for company to review their employment handbook or like other policies to ensure there are effective policies, handbooks following PRC laws, domestic consultation process, including sufficient protection, the sufficient provision so that the company can conduct an internal investigation in a discreet way and also transfer this information out of China without and disclose this to foreign authorities if needed. And I want to note that like many people misunderstood one provision of this Article 13 of PIPL, where there is a provision note if it's necessary to comply with law, then you don't need to get consent. However, complying with law is only PRC law, so not like a foreign law. And in our generally like under PRC law, just noting complying with law is only PRC law, not even Hong Kong law. So in the employment handbook, if we have certain provision addressing disclosing to government authorities, we want to make it clear it's not only Chinese government, it's also foreign government as well. So make sure that we have it drafted in a way that really cover the scenarios that we would encounter in internal investigations. So there are like can be tricky issues when there is a BIOD and we want to have a policy to also beside having company policies which cover the company's right to collect personal information and other data for internal investigation, and the employee's obligation to cooperate and make sure that they sign those policies and handbooks. Is normally we would before we collect common issue the devices. As a best practice, it's not necessary in every circumstance, but as a best practice, normally we would ask the employee to sign a written consent. Because in practice, even though the company prohibit employees to use company-issued work devices for personal use and not to store non-work related information. In reality, employees may still store those information on their laptop. And as such, there has been case under in PRC court where the court found that the company should have expected the employee would store personal information, personal non-work related personal information on the laptop, and the company collected the information illegally on the laptop without the employee's separate consent. But for that, the company was not found liable to compensate the employee, etc. But more because of the way the company collected the information, the evidence provided by the company against the employee were found to be illegally obtained. And the evidence was disqualified for the litigation. And that can impact some sensitive investigation. And so, as a best practice, normally we would have the employees sign a written consent before collecting company-issued devices. And in that consent, we would want to take into consideration the data security laws requirement, the PIPL's requirement, and to draft it in a way to ensure separate consent as required by PIPL are covered in this written consent. And based on many of the investigations we have done, I would highly recommend to have this written consent, because when we collect a work issue device, sometimes you would find that the employee unexpectedly stored WeChat records on the work laptop. And the WeChat information, sometimes it can get into sensitive personal information. And to avoid the dispute down the road, and to ensure that any evidence found through WeChat can be used validly against the employee, we want to have a written consent to be signed in advance to make sure that the company was able to collect it in a legal way. And even during the investigation, we have encountered many cases where there are investigating companies noting that they can provide all kinds of information, like household records, bank account information, WeChat information, etc. Those cannot be legally obtained. There are only limited information which can be legally obtained by PRC licensed attorneys, but generally for the information that I just mentioned, those cannot be legally obtained. So even if it's a industry known investigation firm, if they provide those information, I will not use those which cannot be legally obtained. But WeChat record is something that is really good for internal investigation. There is no legal, if it is a work WeChat, like many of our clients now request their employees to shift to work WeChat for work-related communication, and prohibit them to use personal WeChat for work-related communication, and that works. And it's easy to use work-related WeChat. We heard all kinds of excuses not to use work-related WeChat, but based on our experience, work-related WeChat can be used for communication with clients. For those, the company can obtain the records without the employee's consent. Well, it's difficult to obtain WeChat records. The practice, even if you have company policies is not going to compel them to provide those records. It's best to like one thing is always to check the laptop. We have encountered many cases where there are WeChat records stored. The employee probably have forgotten it. It can be like 2 years ago, but it can still provide very helpful information. And also, during the investigation, during the interview, we can still ask if during the investigation the employee agreed to show the WeChat, we can look at those. Like there are like different practical tips for reviewing that. I don't think we have time to go through those kind of practical tips. And so after an investigation, we want to consider whether to terminate the discipline measures and report it to the PSB. That's important to taking actions is important to show it's individual liability and not corporate liability. I see we are very short of time, and we still want to cover the supply chain, so I'm not going through this like a statement from the government where to note that the criminal liability and the under PRC law these can be separated as well, individual liability and the personal liability of companies. And one thing that this is a case we handled where there are Chinese government investigation and DOJ's US DOJ's investigations at the same time. It's I think it's important to keep in mind for disclosing information, any kind of information to foreign enforcers. It needs to go through the security and the approval assessment. And when there's PSB, we want to be really careful in terms of what information and what kind of investigation steps we can take. And I want to spend a few minutes talking about supply chain because I know that many companies are very interested in this. And for the supply, like supply chain is a hot topic nowadays, and with the human rights issue. And there has been various Xinjiang-related laws passed in the U.S. And well, like with all these new laws passed, companies are building up their supply chain protocols, and to really implement this, companies would need to drive down to see the employees they used, and also the source of materials they use, whether those are from Xinjiang and is not on the first layer of distributed by second layer and down the road. And to do that, if we just terminate a supplier because it's a procure goods from used materials from Xinjiang, or even if we just ask the supplier, are you using goods related to Xinjiang? It's kind of pretty tricky. And we also have seen like some companies conducting human rights review in China, and using questionnaires, asking specific questions related to Xinjiang, or asking some sensitive human rights questions. And that can be getting pretty sensitive in different ways. One thing is China passed an anti-foreign sanction law last year, which prohibits companies to implement or assist in implementation of discriminatory measures taken by a foreign country against like a Chinese citizen organization, and for like laws relating to Xinjiang or human rights issues would fall into this category. And so theoretically speaking, if a company terminates a supplier because it procured materials from Xinjiang, it will violate the anti-foreign sanction law passed by the Chinese government. And with that, it would face one thing is potential sanction by the Chinese government, but we believe that the Chinese government still want to encourage foreign investment and cross-border commercials. So like they will be very cautious in terms of which companies to be put on the list. But for the companies may also face litigations by the vendor who is terminated for like Xinjiang related issue. And the most challenge is that such conduct may attract media attention. We have seen quite a few cases where there are media coverage noting that companies are taking discriminatorial actions against the Xinjiang related companies. So for that, it's going to, if there is such media attention, it's not only going to damage the reputation image, but also it may attract government's government attention, and may trigger other kinds of enforcement. And so with that in mind, the company can still take actions to ensure it's compliant with the law, the foreign laws, but also keep in mind the way to handle it. For example, if a company, a vendor is terminated, is it because of its capability, or it's opposing the company to compliance risk, or is because of its Xinjiang related? How to terminate it? Terminate is pretty important, and we don't recommend sending secondary questionnaires cross-border to different companies. And also, while providing data relating to the CDP, it can trigger the data security law requirement as well, and we want to be careful to assess those. Those are the potential damages. So the key takeaway is that when we are caught in this kind of difficult situations, we want to make sure that the headquarters and the China legal department are aligned in advance, and certain actions are taken abroad would not adversely impact like the China operation, and also be careful in terms of the records that are provided outside, and as well to the employees. Some employees being terminated may expose this to the media as well. Okay, I want to say a few minutes for questions. I see there are already questions.
Yes, thank you very much, Kate, for the insightful analysis. So we've got a couple of questions from the audience. I'll read out the question to you. Article 5 of the National Standard on Identifying Critical Data sets forth a number of factors in considering whether data is critical, including whether the data is non-disclosed law enforcement data. What does that mean? Do criminal investigation records count as such as the interrogatory report made by the investigation authority?
Yes, definitely. And not only like for criminal investigation records, such as interrogatory reports, those are still secret. So it's like at a level even higher than the important data. And so like for like a criminal investigation records, we don't want to review those. And so, but even besides those kind of criminal investigation records, sometimes certain investigations itself is pretty sensitive. For example, if it's a National Security Bureau's investigation in China, just the investigation itself, whether it can be disclosed cross-border, like we need to assess that as well, and that can get sensitive as well.
Okay, thank you. And the second question, in terms of cross-border data transfer, what is exactly cross-border? Is a location of the server that stores the data is the only consideration? What if the data processor making the transfer is located in China, but the data is stored in an overseas email server and the data is transferred via email?
So for the cross-border, it's basically like if someone, I think one thing is if it's if a server is stored outside of China and the information is sent to the server, it will be viewed as cross-border. And if it is data is sent to and if it's a data processor is in China, and it's sending an email to someone outside of China, is viewed as a cross-border data transfer. If it's a service outside of overseas and the data processor sending email overseas server and the receiver is located in China, that's still cross-border as well because the email is transferred outside of China. And also, if someone is reviewing it outside of China, that so if it can be accessed, it's stored, reviewed outside of the border of mainland China, it will be viewed as cross-border. So it can be very broad. And we have even seen a concept that if a foreigner accessing the data in China is viewed as a cross-border as well, but this is not written in law. But we have heard some regulators wants to go that way, and that will be consistent with the state secret. If a foreigner reviewing a state secret in China, that's viewed as cross-border, like disclosing, violating the state secret law. But I think like the minority view is now that a foreigner accessing personal information will be viewed as cross-border at the moment. But just want you to know, like for certain information, for example, important data, some regulators are concerned with that as well.
Okay, thank you, Kate. And we've also got a couple of other questions. Do you find companies are proactive or reactive to this topic? Are organizations wait to see a competitor fined or impacted before responding?
I think we're seeing the companies are pretty proactive, like assessing, taking actions. So for example, after the PIPL and the data security came out, we're seeing companies reassessing their internal investigation and compliance policies, revising their company like employment and handbook to make sure that they have grounds to cover the conducts, the data processing activities they want to do. So I would definitely recommend taking active actions to make sure that we comply with the law.
Okay, and how do you think the investigation landscape is likely to change going forward? Is there any technology out there to ease the due diligence process?
Yes, for due diligence, we're seeing like many technology vendors providing services to help facilitate the due diligence. But I think the real effective ways of doing the due diligence is still looking at like conducting, especially for high risk areas, like interviews is still the best way to doing the diligence. For that, we still need to experienced investigators to do that. But we're seeing, like, for example, to check the relationship mapping and to check whether companies are sanctioned, is on the CBP list, etc. There are technology vendors helping with the due diligence.
Mm-hmm. Okay. So earlier in your presentation, you mentioned the key practical issues for employers to consider when carrying out multi-jurisdictional investigations. In your view, what's the greatest challenge with multi-jurisdictional investigations?
I think for multinational jurisdictional investigations, one thing is like there's conflicts of laws. And so, for example, the China Law statute and the subpoenas in a foreign government. So how to handle data cross-border transfer sampling and disclosure is like a pretty tricky issue. And the other thing is the process of multi-jurisdictions government enforcement is different. Well, to get credit from a U.S. government, a company may want to do investigation and report, but the PRC government will not view thoroughly if the Chinese, if the company is not aligning with them, conducting internal investigations in advance. And also to how to self-report is a pretty tricky issue to report to one jurisdiction or to multi-jurisdictions. I think those are the key issues.
Okay. All right. Thank you very much, Kate, for answering all the questions. I think we probably just have enough time to cover all the questions. And if you do have any other follow-up questions, please reach out to myself and I can forward it to Kate. And I'm sure Kate will be very happy to answer your questions. And I hope, like myself, you found today's session extremely interesting. And I hope you have taken away something from the session. Finally, I'd like to thank Funda Partners and our partner for today's webinar, and Kate for delivering such an interesting analysis in this topic. And if you have any feedback for us regarding today's webinar, or if you would like to see similar topic in other jurisdictions, you can find my contact details on our website. Thank you very much for watching and participating. Enjoy the rest of your day and take care.